Hello everyone. Today in this video, I'm going to share with you on COVID-19 Temporary Measures Act 2020, which was passed by the Singapore Parliament yesterday and on 7 April. So the key measures of the Act are listed here. Firstly is to provide temporary relief to companies who are unable to perform their contractual obligations due to a COVID-19 event. So one good example is that with the Malaysia lockdown, a lot of factories would be closed. So for example, if you're a company in Singapore who source your supplies from Malaysia, it would then mean that you will not be able to get your supplies from Malaysia during this period, and therefore it will cause a delay in you getting in basically to meeting your contractual obligations to your other party. So in such a scenario, you would be able to seek temporary relief under this act. So the other two measures would include temporary changes to the bankruptcy and insolvency laws to increase the debt thresholds for winding up and bankruptcy, and to also give a safety net to allow businesses to continue to trade while technically insolvent. The last is to allow for the conduct of certain meetings such as AGMs to continue using alternative arrangements other than personal attendance. So on the temporary relief for inability to perform contracts, it is applicable for contracts entered into or renewed before 25th March and to obligations to be performed on or after 1st February 2020. It would be for a period of 6 months, but this may be extended up to 12 months depending on the COVID situation. The maximum period will be kept at 1 year from the Act's commencement date, and note that these reliefs are temporary and obligations must be performed at the end of this suspension period. These are the applicable contracts under the Act. So one key point to note is that for loans, it is only secured loans are covered under this Act. And then these are the prohibited actions under the Act. So basically, once you seek temporary relief under this Act, the counterparty will not be able to commence any court or arbitration proceedings or take any bankruptcy insolvency action. They will also not be able to do things like terminating leases or repossessing any of the property or any goods that is used for the purpose of trade businesses. These are the other additional reliefs for specific contracts. So for construction or supply contracts, there is a limitation in calling performance bonds. There is also the extension of performance bonds, as well as that liquidated damages are to be disregarded during the period. And for event or tourism-related contracts, any non-refundable deposit must be refunded in a fair manner, meaning that the deposit, you won't get a refund automatically. Basically, they have to assess whether any expenses are used, and the deposit will only be refunded net of these expenses. And also, no cancellation fees will be payable if the inability to perform the contract was due to a COVID-19 event. So how are the reliefs implemented? Reliefs doesn't come automatically. So in order to seek relief, the affected party will have to send a notification of relief to the other party. And the other party has the right to reject it. But if they do accept the notice, it means that they are not allowed to take any of the prohibited actions listed in my previous slides. If the party chooses to reject the notice, then this notification will be referred to an assessor that is appointed by the Ministry of Law, and there will be no appeals following a determination by assessor. So what this Act means to businesses, like I mentioned earlier, the measures does not provide automatic coverage, so you need to send in a notification of temporary relief to the counterparty. So if let's say the counterparty decides to reject your notification, it goes to the assessor that was appointed by the Ministry of Law. So one key point to note here is that lawyers are not to represent any of the parties during a hearing. So basically, it means that you can get lawyers to help you draft the notice, to give you advice on what to do, but they are not supposed to represent you at any of the hearings. Another thing is that it does not cancel any of your liabilities, and it does not remove any rights of the creditors. The Act basically, what it really means is that it just puts your obligations on a temporary freeze for the stipulated period. So once this period is over and everything settles down, companies will have to pay and meet their obligations, and creditors will have the full rights to take enforcement actions. And again, to re-emphasize, this Act does not cover unsecured loans with banks. So this is just a table to show how this Act really means to the different businesses. So for example, in the commercial and industrial property leases, if you're unable to pay your rental, there is a suspension up to 6 months. So basically, the landlord will not be able to terminate your lease or evict you even if you don't pay. Then there is also under the construction and supply contracts, you might not be able to meet your deadline as I described earlier. Then there is a deferral of this contractual obligation. There will be no liability if you're unable to perform. Then again, for event and tourism related contracts, deposits cannot be automatically forfeited. Fair treatment has been taken into account, all the expenses that has been incurred before a deposit can be returned. Also on the loan facilities, on secured loans, basically once you seek relief under this Act, there is no enforcement of security, and the court or insolvency proceedings will be disallowed. So how should companies be prepared during this period? If you have loans, companies should communicate to your lenders, because it is very important to seek their understanding that you have exhausted all means before considering this temporary relief. Why do I say that? Because after the stipulated period, you would still have to pay whatever outstanding loan you have. So basically, right now, if you were to take up this relief, you are basically telling your lenders that, hey, you have to cease any form of enforcement action to make me pay during this period. So of course, then this relationship may no longer be cordial towards the end of the stipulated period. So you have to speak to your lenders, communicate, and also be prepared for the worst when the temporary relief ends, when the payments are due. Also, use this period to plan ahead. Assess the situation. So if you're aware that you're unable to pay the outstanding loan after the relief, then it is very important that you speak to your lender early to seek for an extension of time. Make them understand why you need this extension, and get them to help you tide through this difficult period. Also, you can also make use of this 6 months period to restructure your debt with the lenders to see how you can come up with a more permanent repayment solution. So do remember, this temporary relief can work against you if you do not manage it well. So really, companies, what companies need to do now is to be prepared during this 6 months period and see how you can restructure your loan so that you can better manage your debts. The next is the temporary amendments to the bankruptcy and insolvency laws. The demand period has been extended from 21 days to 6 months. And for individuals, the threshold has been increased from 15,000 to 60,000. And the suitability for debt repayment scheme has been raised from 100,000 to 250,000. And for businesses, the threshold has increased from 10,000 to 100,000. And also directors, partners, trustee managers will also be temporarily relieved from their obligations to prevent their companies trading while insolvent. Again, it is only if the debts are incurred in the company's ordinary course of business. Lastly is on the measures for conduct of business. So companies can now make alternative arrangements for any meetings where personal attendance is required. So for example, meetings can take place electronically, quorum can be reduced, voting can be made by proxy, and you can also considering deferring the meeting if that is a possible measure. So that's all I have on this Act. Thank you for your time.